all praises, all praises to the heavenly, holy, almighty creator of infinity, eternity, the universe, and all there is. This is Revelations.Unveiled. Detroit. Hello, family. We are back together again in our wonderful consensual assembly of care, concern, and compassion as we coordinate this congregation, as we convene in this convocation. All praises. And to the brothers and sisters of the 12 tribes of the house of Israel and the pending Israelites, my brothers and sisters of the world, my extensions of peace and harmony for your safety and security as we continue to sojourn amongst these heathen. All praises. And family, we are back together again. We have our swords and our shields, and we have donned our spiritual armor, and we head back into battle once again against the treachery and travesty of transgenderism as they try to serve up these sodomite sensibilities to the supreme holy saints of the covenant. And so, family, we will be reviewing an article that is actually from the backyard of my old stomping grounds here in Detroit that has reached all the way up to the highest depths, or the highest levels of the Supreme Court. And so, we are once again the soldiers of righteousness as we get on the expressway to eternity, as we expand, elevate, and escalate our mental and spiritual properties as we continue in the battle and this common carnal captivity on this continent of confusion. And so, we always head into the battle under the standards at Revelations.Unveiled. Detroit in the book of Hebrews chapters 3 verse 6, as well as Hebrews chapter 13 and verse 8. Those are the standards which keep us grounded into this developing army of righteousness as we fight the battle here in these carnal containers to be the leading light of the Holy Creator. All praises. And we shall begin. The title of this evening's article of review: The Supreme Court hears AIMEE Stevens transgender discrimination case. And so, family, as we are becoming more fortified, as we grow in our rankings as a spiritual army, when we address these type of topics, we try to keep down the confusion. So the subject of the article is AIMEE Jacobs. Now remember, we're talking about the world of transgenderism, the travesty of deceit and deception, where we must examine the mental defect that turns our brothers and sisters into demonic vessels, where they are trying to proffer the idea that we should accept the fact that they don't accept themselves. And so, when we say she, it's more than likely a he. So we say he, she, he. But this is a man who is living and posing as a female. So the baseline of it, we're talking about a man who wants to be a woman. So when you hear the word she, it's actually a he. And when you hear him, it's actually a her. So, like I said, we try to keep down the confusion. We'll go through this article, and then we will tender our commentary about said subject. For nearly 6 years, AIMEE Stevens' job at RG and G.R. Harris Funeral Home in Garden City, Michigan, was to attend to the bodies of the deceased, to dress them in clothes brought by their loved ones, to set their bodies, their faces for viewing, to make them look normal, she said. But if normal means conforming to some societal standard of what a person is expected to look like based on one's name and gender, AIMEE Stevens is struggling with it himself. Born, or assigned, parenthetically stated, in current parlance, with male genitalia, Stevens, by July 2013, at age 52, had been living for some years outside of work as a woman, dressing only as a man at work. A year earlier, she had considered killing himself, standing in his Redford Township backyard with a gun pressed to his chest, tired, she said, of living a lie. Finally, she confronted his boss with a letter explaining who he really was, and him decision to begin dressing as a woman at work, which had a strict and distinct gender-based dress code. The funeral home owner, Thomas Roast, told her, "This is not going to work." And when he turned down a severance package, he sacked him. 6 years later, Stevens' case has come to the U.S. Supreme Court, with justices hearing arguments October 8 as to whether federal law, or specifically the Civil Rights Act of 1964, prohibits discrimination against transgender people. All right, family, we got to pause here. Family, this community, and they refer to them as the alphabet community, have hijacked the law that our elder civil rights leaders marched and were stoned and were killed, assassinated, bombed, terrorized to secure for the benefit of uplift for us, the so-called black people here in America, for the course of action against us over almost a half of a millennium. And these people are putting their filthy hands on the sacredness of one of the rewards of the actions of our elders. That is of the highest and grossest offense. And we must continue to battle and speak against this. And we continue. And Stevens will be there. She says, "I can't say I'm worried or nervous, but it's been a long time coming," said Stevens, speaking in a soft southern drawl that reveals her North Carolina upbringing. "I only hope the justices will listen to reason and look at what the lower courts have said. He never dreamed he would be in these circumstances, but said he has no regrets. It was either send the letter or not be here anymore. But there are reasons for his supporters, and support, who include Orange is the New Black star Laverne Cox, who gave the case, and Stevens, American Civil Liberty Union's lawyers, a shout out on the red carpet at the Emmys on September 23rd to be worried. 4 years after the Supreme Court decided 5-4 that same-sex individuals had the right to wed, the court has changed dramatically Justice Anthony Kennedy, who wrote the majority opinion in those earlier cases, which included those of two women from Michigan, April DeBoer and Jane Rouse, is gone. He has been replaced by Brett Kavanaugh, who was appointed by President Donald Trump and who went through a bruising confirmation fight with Democrats as several women accused him of sexual assault, though he denied the accusations and they were never adjudicated. And while guessing in advance how a justice may rule is risky, Kavanaugh is generally seen as more aligned with the conservative wing of the court, which includes Chief Justice John Roberts and Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch, than Kennedy was, leaving lots of LGBTQ RSTUV advocates and their supporters nervous. So, family, I interject that I am not Republican, yet I am independent conservative and kind of rigid in that space. So, moving race aside and moving characterization aside and the politics, if I stand on my stance in opposition to the LGBT agenda, then I align with President Trump as he nullifies and throws out all of these rulings, which expands these territories where they can interject this agenda of sodomy and treachery. So they are now worried that the Supreme Court is becoming even more staunch and will rescind and roll back all of the opinions and or influences that the former Justice Anthony Kennedy had. Stevens' case will be heard on the same day the case hears sexual orientation discrimination cases. In those two cases, one involving a skydiving instructor who has since died and another a Georgia child services coordinator, the court is being asked whether it was legal for employers to fire them because they were gay. It's not just high court changes causing concern. Transgender status is not specifically mentioned in the Civil Rights Act, and it's not supposed to be, family. I digress. That means whether it should apply in transgender cases comes down to how courts have dealt with questions surrounding gender in the past and what that term means. Whether it is what society once may have accepted as a binary biological fact of male or female, or whether it's something more personal wrapped up in one's individual disposition. And see, family, that last sentence right there, or last segment of the sentence, is where it goes crazy. Wrapped up in one's individual disposition. What if their disposition is stark, raving, homicidal, psychopathic, sociopathic killer? Should we allow that? Continuing. It also raises questions about cultural stereotypes and what it means to present oneself as a man or as a woman or something else entirely. Those are cultural questions. The legal ones don't end there. While the Supreme Court has ruled in the past that gender stereotypes can't be used to punish or hold someone back in their career, the funeral home's lawyers argue that Roast, a devout Christian, also has rights under existing law to enforce a gender-based dress code as long as it doesn't advantage or disadvantage one sex over the other, just as employers can have separate bathrooms based on gender without being accused of discrimination. Roast lawyers say that if a biologically assigned female had asked to dress as a male despite being transgender, the funeral home would have made the same demand. So there is no disadvantage between the genders to be litigated. A 3-judge panel at the U.S. 6th Circuit Court of Appeals in Cincinnati ruled last year for Stevens. However, declaring that firing her for not dressing in a way that conformed with Roast's definition of gender violated a Supreme Court ruling that any kind of gender consideration must be irrelevant to employment decisions. So family, y'all see all this confusion and madness up in here? It's not simply I'm a man and you're a woman. You're trying to impose sexes and genders and feelings and irrelevancy in decisions. So the gentleman runs a funeral home and he is comforting people in their time of mourning, and he is trying to make everything as pleasant, as at ease, as serene as he can in their time of solace. And to have this major distraction of a big burly man dressed as a woman there would be disruptive to the course of his work. I digress. It's analytically impossible to fire an employee based on that employee's status as a transgender person without being motivated, at least in part, by the employee's sex, that court found. And that's back in reference to the 6th Court's decision. But Roast lawyers argue the court effectively and improperly rewrote the law, defining gender as a personal disposition and not as a biological fact. And they say it's the latter definition, not the former, that was held by Congress to be the case in 1964. It's a fascinating time to be alive, though in this case, certainly wasn't anything I was looking for, said John Birch, a West Michigan lawyer who argued against the same-sex marriage decision before the Supreme Court on behalf of Michigan's Attorney General and who is now working with the Alliance Defending Freedom, a Washington group that advocates for religious liberties, to argue Roast's case. I do feel strongly that every person is entitled to rely on what the law says, said Birch, who will lead arguments in this case. And this is a clear instance where the 6th Circuit Court of Appeals rewrote the statute to punish a business based on acts that were fully in accord with federal law. If that decision were allowed to stand, he said, it could have all sorts of ramifications, raising questions, say, about programs intended to ensure equality and fairness for women in education and in employment, in sports. If sex means your own internal sense of what your gender is, then that opens the door for boys to identify as girls and compete against girls, he said. That is happening right now. Stevens lawyers say that's nonsense and that it's not a question of gender-based dress codes, but whether an employer should be able to fire someone for not conforming to their ideas of sex. All right, family, another interjection. So, we can take the sex out of it, or the gender part. If I impose upon, or if I, as a part of my policy of my business, a dress code, And if everybody wears long sleeve shirts and slacks, that's the dress code. Everybody, male or female. If someone comes in and tells me or insists that I allow them to wear a dress, I will hear them. I will read the policy imposed by the business. And if they, as an employee, don't conform to the policy, they can leave as an employee, or I, as the employer, will fire them because they are insubordinate to company policy. So they can't tell you or make you feel that you discriminating against somebody based on their gender. Even if you are, you can say, I have a policy that this person does not abide by, so we agree to separate our relationship, plain and simple. AIMEE, being AIMEE at work, was not going to upset the apple cart, said Jay Kaplan, staff attorney for the ACLU of Michigan. She was fully willing to comply with the funeral home's dress code for women. There's the problem again, family. This man is not a woman. What are they talking about? It's madness, utter madness. And Kaplan says federal courts have been consistently moving toward recognizing that discrimination against transgender individuals is disallowed, in part because of a Supreme Court case in 1989 that ruled against the use of sex stereotypes. In that case, the court upheld part of a lower court finding that it is improper to use a sex stereotype that some believed a woman was too aggressive to justify denying her partnership at accounting firm Pricewaterhouse. Since then, that decision has been used to bolster numerous discrimination actions. The Supreme Court will have to overrule itself, said Kaplan, adding that if that happened, it could roll back discrimination practices across the board. There's a lot at stake for male and female employees. Stephen no longer works, despite loving what he did. 6 years after being fired, Stevens, 58, is unemployed and on medical disability. Even though he had prior experience and had been certified as an embalmer in North Carolina, he couldn't find work after Rose fired him. Unfortunately, he got a job as an autopsy technician in a Metro Detroit hospital, but in late 2014, he suffered kidney failure and had to leave. He is on dialysis 3 days a week, but he's alive. Him's relationship with her second wife, Donna, is still solid. Wait a minute. Hold on. Him relationship with his second wife, Donna, is still solid. Stevens told her some years before she confronted the funeral home owner how he began presenting as a woman. A change that both seemed to agree made it easier for Stevens to accept and understand who he is. Oh my goodness, family. So the man was married and he told his wife, and his wife was agreeing with him. Okay. I know I'm much happier with who I am, said Stevens, adding that Donna has noticed the change too. And as for their neighbors in Redford, Stevens said they have shown nothing but support over the years. But it hasn't been easy. Her wife still works full time, but money is often tight. Sometimes, she said, resources are hard to come by. Our noses are always just above water, she said. We don't have a lot. And Stephen has had to make sacrifices. For instance, when on July 13, 2013, Stevens handed Roast a letter saying he struggled with gender dysphoria her whole life, he added that he intended to have sex reassignment surgery and that living and presenting as a woman was part of that process. All right, family, there it is. There is the recognition of the mental disorder. We're talking about and dealing with a person who has been condoned and sanctioned and encouraged, a person dealing with the mental disorder or defect of gender dysphoria. So all of these actions are based on this mental developmental issue that is reached all the way up to the Supreme Court. Oh my goodness. Because of her medical condition, however, he and her doctors have decided that going through reassignment surgery may be too dangerous, meaning he likely will have to give up on any hope of making a change that he had wanted so badly. It's something that I've had to think about a lot, he said. I've made peace with that now, and if I don't ever get to have surgery, I can live with that. Then there's the loss of her job, which he had surprised her. While he suspected that Ross may be uncomfortable with her decision, he didn't expect what he considered such an extreme reaction. I loved my job. I liked doing what I was doing. It was a way for me to help families remember their loved ones, he said. Death is never easy to handle to begin with. But to have a negative lasting memory is not good at all. And that was something that I could help change. But as he said, no regrets. Not after a lifetime of feeling different from other people. He said he probably was 5. And growing up in a Baptist family when he began to know he was different than other kids. Though it will be decades before he could explain even to him or herself how he felt. They offered me a severance package that I could not accept, but I couldn't keep my mouth shut for the rest of my life, he said. It was too important. Roast's lawyers said he carefully considered his options. Roast wasn't happy to speak to the free press, but according to his lawyers, he didn't make a snap decision about the dress code and Stevens' letter. They say he took 2 weeks to consider it and how it might affect other female employees and clients who would be sharing a single-sex restroom with Stevens. They say he thought about the impact it might have on grieving families, and he decided it was best for Stevens to leave. Ultimately, the Equal Employment Opportunity Commission took up the case, but lost in a ruling by U.S. District Court Judge Sean Cox, who noted that transgender or transsexual status isn't a specifically protected class under the law, and that Roast's religious opposition to Stevens' transgender status protected him from any sex stereotype claim. The ACLU and Stevens argued successfully that past court decisions made such a ruling improper, and what the Sixth Circuit Court upheld. But Burr said that the Supreme Court needs to overturn the Sixth Circuit based on what Congress meant in 1964 by sex. So they're trying to impose this new societal creation of transgenderism on a 1964 law to hide it under the guise of being a civil rights violation. There was no civil rights violated. This man could dress as a woman all he wanted to. He just couldn't do it at work. And while it has never been specifically or conclusively decided Neither has Congress passed any law giving transgender individuals protected status or enacting a broader definition in the law, which it could have done. Congress has considered this and rejected it, Borsch said. They did amend the statute. When the Supreme Court concluded that sex discrimination did not include differential treatment based on someone's pregnancy, Congress immediately responded by amending the act. And even though courts have rejected claims based on transgender status, Congress never acted in response to that. Meanwhile, Roast lawyers reject comments made at the AIMEE suggesting that if Stevens loses the case, it will result in sexual stereotypes being legally enforceable. They say their argument is that gender-based protocols such as dress codes are allowed as long as they are equally applied. It's only stereotypes that treat one gender worse than another that are prohibited. On the other hand, many people feel that telling someone how to dress based on their biological assigned gender is inherently wrong, and that violating that in itself is discrimination. But if the AIMEE's comment proves anything, it is this: that the issue comes down to a question debated far more openly in society today than it was in 1964 when the law was passed, which is whether gender is or should be an objective, observable fact or past, which is, let me go back. The question was, in 1964, when the law was passed, which is whether gender is or should be an objective, observable fact or something more closely held, something inherent inside of a person. AIMEE Stevens would have been about 3 in 1964. At most, she had 2 years before she began feeling, as he said, different from all other kids. But still, he has no regrets. I'm happy to be where I am at, she said. I'm just not happy how I got here. All right. So family, we have went through the review of a issue that became a legal case that has transcended up to the Supreme Court, where now it is going to be determined by 1964 civil rights law if this person's rights were violated because they were fired for wanting to dress or impersonate a woman at their place of employ. So family, when we consider and ponder all these elements, all the ridiculousness and the just utter madness of this transgenderism, where we're actually not dealing so much so with a sexual issue. This is a mental issue. This is a mental issue, and thus so was classified until about 30, 40 some odd years ago, when it was removed from the psychological dictionary list or psychiatric list. I get the formal name of the document, where it was outlined that these alternative sexual lifestyles were actually mental illnesses. So once again, we cannot be fooled. We cannot be bamboozled. We cannot be hoodwinked, led astray, and run amok with this demonic, satanic agenda that is being slowly unveiled before our eyes, hoping to capture the younger generations and the children So family, we continue to endeavor in the fight, in the battle for the root of righteousness as we continue to extend and escalate and elevate. And we shall be true to the cause. We shall be true to the revelations of righteousness and truth of our holy power creator. We shall continue in peace and safety. We shall persevere and endure. And until we are together again, family, I love you. I love you. I love you. This is Revelations.Unveiled. Detroit.